This week we will be focusing on legal writing. Now, we've already looked at legal writing before in relation to the drafting of correspondence in week 4, but this week we're focusing on the type of writing that is connected to the research portfolio that you will have to complete for the final assessment in this unit. So we're going to be looking at how to present arguments in response to a request for submissions by a law reform committee, and also more generally in relation to theoretical essay questions at law school. You may have already encountered theoretical essay questions before. Those don't involve a factual matrix and advice to a client. They ask you to analyse a particular area of the law in a more abstract setting. You may find that these types of assessments appear quite frequently from this point onwards, and you may even be asked to do a law reform submission or a research project as part of another unit. So this particular module is designed to help upskill you for those types of activities, as well as helping you with your research portfolio. Now, note that for the workshop this week, you will only be preparing a detailed plan. You won't actually be writing a law reform submission or a report for your supervisor on the law reform topic that you've selected. But part of the process of preparing a detailed plan includes looking at what you intend to say paragraph by paragraph, identifying what sources support what you're trying to say. So you are in essence constructing a series of arguments in that detailed plan. So this video will still help you with that, as well as helping you with presenting arguments for theoretical essay questions and law research projects that you may have to do in other units in the future. Now, my top tip for today is to plan before you write. Structure is essential because it helps you identify the best way to present your information, and it may be that you keep reworking that structure for a couple of days until it really works and it really flows into your conclusion, and that's good. It's better to do that at the planning stage than it is to be taking huge slabs of text and trying to move them around and make them work. So structuring your work and identifying a suitable plan for the communication of the information will actually save you time in the long run. So one of the things that you need to do is think about how you intend to present the discussion. Are you going to adopt a particular perspective, so adopt a particular stance and present all the reasons why that is the logical stance to adopt, but also counter the other side's arguments with evidence in support? That's one way you could do it. The alternative is to weigh up the arguments on both sides and then reach a conclusion at the end. But note that you will need to reach a conclusion and adopt a stance at that point. Otherwise, the essay is really just here's everything that I know. So it has to have that analysis flow through it, and you build momentum towards a conclusion. So as you analyze, as you go through those competing arguments, you start to identify which side of the argument you're going to support. In both of those cases, it's a really good idea to identify headings and subheadings. Really what you're looking for here before you get a 2,000 word document is whether or not your key headings flow logically into the conclusion. That will tell you whether or not there's more that you need to do in the structure, whether it's more arguments that you need to present on one side, whether you need more analysis or more sources. In addition to identifying the headings, you also need to provide a summary of each argument, key argument that appears under each heading. So you take one heading and either with dot points or bullet points or a brief summary, note what key arguments you will discuss there and the sources that you will use in support. And that sounds like a lot of work, but it will stop you doing this at the end during the writing process. So you'll be writing away, you've got a great idea, you're in the flow, and then you think, I don't know which source that was in, I'm going to have to go and read 3 journals. So what I'm trying to say is that all of this planning here will streamline the writing process for you. It will also enable you, if you do note those sources that support the arguments that you're going to make, it will help you see whether you've got sufficient evidence and whether you need to do any last minute research on 1 or 2 points. So again, that will save you having to break that being in the writing zone and go and do some research to support what you're saying. So the pre-writing process, the planning stage, actually saves you a significant amount of time later. Once you have the plan ready and you're happy with it and you know that that's how you want to present the information and the analysis, you need to focus on writing the body. As the study guide notes, the introduction and conclusion should be written last. It makes sense to do it that way because they reflect the body of the essay. The introduction outlines the issues, the legal issues, why you're looking at them, and how you will proceed to look at them. And the conclusion provides an overview of your discussions and then provides an overall view. So in both of those cases, there is little point in writing them until you are certain that the body of the essay represents what you want to present as your assessment item. Otherwise, you'll end up having to rewrite the conclusion and introduction a couple of times as things change, as your work flows and changes. And note that even if you have a detailed plan, occasionally you will feel the need to delete sections or rewrite sections. That's all perfectly normal and part of the writing process. It's quite usual to write something and then think, hang on, I think I can do that a bit better. Or I think that this would flow better if I started the sentence or the paragraph like this. That's all perfectly normal. But that pre-writing planning stage, the more that you do there, the less you will be in that position of making huge amendments and huge changes at the last minute. Now, the study guide looks at some of the most common problems we see in students' work, like run-on sentences, comma splices, and the use of the passive voice. Often it is assumed that lawyers sound more professional if they use complex sentences, but that's really not the case today. If the sentences are too complex, it can be difficult to follow the arguments that are being put forward, and the central point in the sentence can get lost. Instead, lawyers strive for plain English drafting. It's expression that is deliberately chosen to be clear, precise, and concise. If we adopt a plain English drafting style, it reduces the likelihood of ambiguity in a contract or a client misunderstanding the advice that you've provided in a letter. And we can still apply the principles of plain English drafting even in the context of a research project. We want the discussions to be clear to the reader. We want the reader to understand your arguments, how they fit together, and how you reached a particular conclusion. So with that in mind, here are a few top tips for adopting a plain English drafting style. I would like you to be alert for the use of the passive voice when you're reading your work. This generally makes the sentence more complicated than it needs to be, and in lengthy sentences, the point can become lost or convoluted. The passive voice can do two things. Firstly, it can take the usual sentence construction and switch the order around. So the usual order is subject, verb, object. The passive voice takes that subject and places it at the end of the sentence, and the focus then switches from being on the subject to the action itself or the object receiving the action. So let me give you an example. The application was filed before the deadline on Monday by the appellant. Now, who is the subject in that sentence? Well, if we were following the traditional pattern, it would be the appellant because it's the appellant that files the paperwork. The verb is obviously filing. What is the object in the sentence? In a usual sentence construction, it would be the application because that is the thing that's being filed. Okay, so in that sentence I just read out, the application was filed before the deadline on Monday by the appellant. The application is the object, that comes first. Then we've got the verb was filed, and we don't find out who has actually filed that application until right at the end. The very last part of the sentence is by the appellant. So you have to listen to the whole sentence to work out who filed the papers. It's much more clear and concise to say the appellant filed the application before the deadline on Monday. The appellant, the subject, filed the verb, the application, the object, before the deadline on Monday. It's much shorter, much more clear as well. Now, the second thing that the passive voice can do is disguise who undertakes the action, i.e. the subject, altogether. So let me give you an example. The papers were submitted on Friday. Now, submitted is clearly the verb, and what's being submitted, it's the papers, so the papers are the object. We've got no clear indication who submitted them, so we've got no indication who the subject is in that sentence. So both of those examples are relatively straightforward, but imagine a more complex sentence, or a sentence that is full of difficult information for the reader to grasp. If you then express that sentence in the passive voice, you make it really hard for the reader to follow what you're saying. The reader has to do a lot of work to grasp what you're saying, and quite often has to wait until the end of the sentence to get the full picture, because that subject is appearing right at the end or not appearing at all. Now, the study guide also talks about the use of superfluous words. And what we mean by that is where a phrase is used when in fact just one word would do the job. And some examples include things like the phrase "as a consequence of." Instead of writing those 4 words, you could just write "because." Another example is "as a result of." Again, you could just write "because." So in those instances, there's nothing grammatically wrong with those words. But when you have a word count and you're also trying to communicate in as concise a manner as possible with your reader, especially when it's complex material, it needs to be as concise and clear as possible, then try to avoid those phrases that just add length to the sentence and therefore make this sentence more complex. Another way in which we see an increase in words is through the process of verb nominalization. Now, that is in essence when you take a verb, like the verb to negotiate, and you turn it into a noun. So negotiate would become negotiation. If you use negotiation in the sentence instead of the verb, it becomes a lot longer. You need to find a new verb to go with the noun negotiation. Okay, let me give you an example. So instead of saying the parties negotiated, you would have to say the parties entered into negotiations. So we've taken negotiated and turned it into negotiations, but because that now doesn't make sense, we have to extend the sentence and introduce a verb, which is entered into. So we have the parties entered into negotiations is longer and more complex than the parties negotiated. Again, there's nothing grammatically wrong with a verb nominalization, but it does increase the length of the sentence. And if you're working with complex material that the reader is going to struggle to grasp anyway, because it's got difficult theoretical concepts, say, then in those instances you want to keep the sentence as short and concise as possible. So if you take a look at the slide there, you can see that on the right-hand side we have contractions. Contractions are where you take 2 words, put them together, and then use an apostrophe to symbolize the missing words. So take, for example, the first one, you are. By contracting you are together, we have your, and the A is removed and replaced with an apostrophe. It's the same with their, they are, and it's, it is. And on the left-hand side, we have possession. So that's your car, that's their house, etc. Now, one of the most common errors we see in work is a failure to use the appropriate it's, i.e. it's possession, or it is, which is contracted to its. Note that if in the sentence you could rewrite the sentence to say it is, then you need an apostrophe. For all other times, you'll just need to write it's without an apostrophe, so the possessive version. Another point to note is that we try to avoid contractions in legal writing anyway, because they are more casual and therefore look less professional. So really you shouldn't be using it's as in it is as a contraction in your work anyway. Note that we have 3 types of there. We have the one on the left there, which is THEIR, which symbolizes possession. We have there, which is on the right, which is the contraction of they are. And then we have there, which is THERE, which can be used at the beginning of a sentence. For example, there are several problems with this hypothesis. It can also symbolize place. So one of the most frequently asked questions whenever I'm in the car with my kids is, are we there yet? So please make sure that you're paying careful attention to whether you have the correct version of there and its, and think about avoiding contractions wherever possible just because they look less professional. Note that in your time planning, you need to allow time for proofreading and editing your work. Things that you may regard as small or relatively unimportant, such as formatting or typos, are in fact very important when it comes to the overall impression that you create with the reader and the marker. So if your paper is full of typos or the formatting's all over the place, it will give the impression that you have rushed your work. And what that tells us is that you have raced to the deadline to such an extent that you didn't have time to proofread. And remember that your first draft is not your final draft. You need to make sure that you thoroughly evaluate your first draft, identify areas that do require work, and work on them before moving to a proofreading stage. Now, the workshop task this week is to prepare a detailed plan. This is the kind of plan that you would compile for your supervisor as part of the process of preparing a law reform submission or a report on the law reform topic. Now, we covered what goes into a detailed plan at the beginning of this video, so you might want to rewind the video and focus on that particular section. This is really designed to encourage you to focus on what you're going to say and think about all the sources that you've collected, and you produce a really comprehensive product at the end because you've really analysed what sources go where there's contradiction, where viewpoints align. So the idea is to really help you focus on producing the best product that you can.